All rise. Judge Vanderbeek Court is now in session. Judge, this is case number JVB 1034, Thornton case.
Thank you.
You're welcome.
You all may be seated. Mr. Thornton,
Yes, ma'am.
you're back. How are you doing?
Oh, not as well as I'd like to.
Okay, all right. You brought this case before the court. What's going on?
Well, Your Honor, there's been some significant changes in my situation. And as you can see, Ms. Hernandez is not here today. And I have custody of the boy, and I have been, making our arrangement payments to her.
Okay.
But since the boy has come to...
Courtroom drama unfolds. A custody battle with high stakes. The tension is thick as the judge's gavel hits the desk, calling for order. In the spotlight stands Mr. Thornton, prepared to make his case. He currently has custody of his teenage son, AJ, and has been consistently making support payments to Miss Hernandez. But beneath the surface, a storm is brewing. AJ has landed in serious legal trouble, accused of burglary, and involved in a dangerous police chase that ended in a dramatic crash. As the judge probes deeper, the focus shifts to AJ's living situation and whether his financial needs have changed. Mr. Thornton, visibly strained, explains the mounting costs of his son's actions, from legal fees to damages. Yet, this battle isn't just about money, it's about responsibility, consequences, and the difficult reality of parenting a troubled teen. Now, the courtroom holds its breath. The judge is about to make a critical decision, one that could reshape this family's future. What will the verdict be? Stay tuned.
Stay with me, he's gotten himself into a lot of trouble.
Okay. What kind of trouble?
Well, he's been burglarizing some residents, and he was in an accident due to a police chase.
This is AJ, right?
Yes.
Okay.
And Ms. Hernandez refuses to acknowledge her responsibility to help me in covering some of these costs. I mean, the medical costs are quite extreme. My insurance is refusing to pay because it was a criminal act. In fact, they're probably going to drop me.
Okay.
And
if I remember correctly, you guys agreed to no child support during mediation.
yes, ma'am, we did.
Okay. And since that time, nothing has really changed with the living arrangement. AJ still lives with you,
Yes, ma'am.
and you still have not been paying child support. You've been making the back child support.
Father's plea. Can he prove his case? Mr. Thornton doesn't hold back. He lays it all out. Miss Hernandez has left the state, quit her job, and no longer has insurance to cover AJ. That means every expense, medical bills, court fines, and the crushing costs from the crash now fall squarely on his shoulders. The weight is unbearable, and he's feeling the pressure. The judge listens carefully but quickly brings up a crucial point. Their previous mediation agreement required no child support. So, the big question remains. Has there been a significant, undeniable change in circumstances? Thornton fights to make his case, but there's a problem. AJ has always been under his care, making it difficult to prove the situation has changed enough to warrant legal relief. Frustration is written all over his face as he realizes the legal battle ahead won't be easy. The stakes are high, emotionally and financially, and while Thornton is desperate for help, the judge is sticking firmly to the law. Can he find a way to shift the case in his favor? The tension in the room is mounting, and the outcome remains uncertain.
Payments.
Yes, ma'am.
Okay. Other than AJ getting in trouble, what else has happened? Like, what has changed?
Well, she has moved out of state, quit her job, so her insurance no longer covers him.
Okay.
In that aspect. And, the court costs, fines, and due to that accident, there was a lot of damage in which he's liable for, or I am, and it's almost impossible.
Okay.
For me to,
But AJ was double insured by both of you, right?
yes.
Okay. Here's the issue. In order to modify any type of child support situation, whether you receive child support or you don't receive child support, there has to be what's called a material and substantial change. That means that AJ's living arrangements would have had to have changed.
A tough pill to swallow. With a firm grip on the courtroom, the judge lays down the law in no uncertain terms. To alter child support there must be a major undeniable shift, whether in living arrangements, income, or educational needs. But after reviewing the facts, she finds no such change since the original mediation agreement. Mr. Thornton's frustration is impossible to miss. He sees Ms. Hernandez as having walked away, leaving him to handle everything alone. But the judge stands her ground. She reminds him that the agreement was made mutually and that the law doesn't bend for emotional hardship. It requires solid legal justification. This is the turning point where logic and raw emotion clash. Mr. Thornton's plea for fairness meets the unyielding letter of the law, creating a tense courtroom moment. And just like that, the decision is final. The weight of disappointment sets in, leaving no room for argument.
Something about his educational expenses have changed. Something about mom's income would have had to have changed. But in you guys' case, you agreed in mediation to no child support. So to go from no child support to receiving child support, you would have to fall in one of those categories for a material and substantial change. And based on what you said, you really don't fall into one of those.
That's very disappointing. So she's just free of any obligation? I mean...
Well, I wouldn't say she's necessarily free, but remember, you all did come to an agreement in mediation to no child support. So in order to start receiving child support, you would have to show that something has changed. So let's say, for instance, at the time of mediation, AJ still resided with her. Now he lives with you. Then we can...
Case closed. A harsh legal reality with a firm but even tone, the judge delivers her final decision. Under the law, Mr. Thornton doesn't qualify for child support. The mediation agreement remains intact, and without a significant change in circumstances, there's no legal ground for modification. Case dismissed. Mr. Thornton acknowledges the ruling with a quiet, "Thank you, Your Honor," but the frustration, in his eyes, says it all. As he steps out of the courtroom, the financial burden remains, pressing down on him with no immediate relief in sight. The judge's closing words echo in the room. Legal agreements are binding, and without major shifts, they stand as written. It's a sobering reminder of how complex child support laws can be and why every decision made in mediation carries lasting weight.
Entertain child support at that point, but nothing has really changed since you guys have gone to mediation. Therefore, you wouldn't be entitled to receive any child support, unfortunately.
I understand. I mean, is there nothing I can do? Absolutely.
As far as I'm concerned, no, there's nothing you can do. Yeah.
All right. Thank you.
Okay,
Your
is there
Honor.
anything further?
No, ma'am. Not at this time.
Okay.
That's about it.
Okay, well, if there's nothing further, you're dismissed.
Thank you.
You're welcome. I just wanted to go over what you all witnessed in the Thornton case. Dad was appearing in court for the first time. He and mom settled at mediation for no child support. Well, now he wants mom to pay child support. Well, under Texas law, in order to modify child support, there has to be a material and substantial change. For example, there has to be a change in the child's mental needs, educational needs, a relocation of the parent, or an increase of income. None of those things took place in this particular case. Everything pretty much remained the same. Therefore, he was unable to get any child support from mom.
Legal breakdown. Why the ruling stood. This case is a clear lesson in the importance of fully understanding child support agreements and the strict legal rules for changing them. A legal expert weighs in. Under Texas law, modifying a child support order requires a material and substantial change in circumstances. That could mean a significant shift in income, living arrangements, or a child's needs. But in Mr. Thornton's case, the court found no such change, meaning the original mediation agreement stayed in place. As the video wraps up, viewers are invited to share their own experiences and subscribe for more legal insights. The key takeaway? Child support laws are complex, and having the right legal guidance can be the difference between frustration and a favorable outcome.